But they are also arguing that the case must not be heard in London. They want it to be heard in Nigeria.
What's the advantage?
Well, the advantage and the assessment is that if it was to be held in Nigeria, they will be away from the global gaze, because if they are going to have it in London, this is an environmental issue. It goes back to the 2011 report that was done by the UN Environmental Program Agency, and when they did the environmental assessment in the area. So you are going to have a lot of people that are going to be upset about the pollution and the environmental damage that has been done to the communities. So London will, that will cause problems for the brand.
And that was a scathing report that came out in 2011, and 5 years later, the lawyers are saying, and both communities are saying, that it's outrageous that Shell have done nothing about it.
Because at the time there were recommendations that were made, and there were plans that were actually put in place to make sure that Shell go back and clean up the areas and at least work with the communities. So what the communities are arguing, which is why they have approached the Technology and Construction Court in London, is that Shell did not do anything after that.
Look at this, look at this.
These are file pictures from
what can you tell us about the kind of damage, the kind of impact that's being caused to these communities?
Well, most of the communities in the River State in this area, Ogoniland is where the assessment report was actually done. They depend on farming, they depend on fisheries, and the rivers are contaminated, so they cannot have clean drinking water in the area, and their livelihoods are damaged because they are arguing that if they cannot farm anymore, if they cannot get fish anymore, if they cannot get drinking water anymore, simply because there has been contamination or pollution secondary to the bursting pipelines, then Shell must be held accountable. And especially the Bile Kingdom, they are arguing that Shell cannot run away from the responsibility of protecting their property.
They should be liable for failing to protect their pipelines.
That is their argument. So and they are being represented by Lee Day, who are the lawyers that represented the Bodo community that sued after the 2008 and 2009 oil spills, and then there was an out-of-court settlement at that time, which is about 55 million pounds, or about 84.
So Shell has a record of paying. They have a record.
Well, but in this particular case, what they are simply saying is this thing has been going on for so long. They have been, the report is assessment report that was done by the UN Environmental Program, say that they had been sporadic and continuous oil spills since way back, and so you are talking about a lot that has been happening over the years. And there are other reports that are indicating that some of the pipelines must have been replaced by now. They are not in the good condition. So these are the arguments that the communities are bringing to court.
So this particular case involving these two particular communities this time,
the Ogale and the Bile.
Yeah, it's at a very early stage, this one, and the first hearing is in the Technology and Construction Court in London today. I've never heard of that court, but obviously...
Well, it's part of the High Court. No, this is just... the High Court is divided into, depending on what the case is, you've got commercial cases, you've got civil cases.
This is a sector.
So, this is just a sector within the High Court. So it's part of that. You're just having people that sit on the bench to hear the cases who are experts in the particular area. And then you're also going by what is called the cases, or maybe referring to the cases that have gone on in the past, that judgments that have been made in that particular area and court. So you're basically saying, well, this is a specialist court that must be looking at what has happened.
Gotcha.
But obviously, we don't know whether it will actually be heard in London or not. This is just a procedural hearing to decide whether the case itself must proceed in London or maybe be put back to Nigeria.
Tam,